Plaint and written statement. This chapter discusses two important topics, plaint and written statement, and matters incidental thereto. Rule 1 to 8 of Order 7 relate to particulars in a plaint. Rule 9 lays down procedure on plaint being admitted, whereas Rules 10 to 10b provide for return of the plaint and appearance of parties. Rule 11 to 13 deal with the rejection of a plaint. Rules 14 to 17 contain provisions relating to production of documents. Order 7 should be read with Section 26 of the Code. Order 3 enables a party to appear in a court, either in person or through a recognized agent or through a pleader. Order 5 deals with summons to a defendant. It contains provisions regarding issuance and service of summons. This order should be read with Section 27 to 29 of the Code. Order 8 enacts a law relating to written statement. Rules 1 to 5 and 7 to 10 require particulars to be stated in a written statement. Grounds of defense or production of documents. Rule 6 and 6a to 6g deal with the doctrines of set-off, counterclaim respectively. Plaint, Order 7, meaning. The expression plaint has not been defined in the code. However, it can be said to be a statement of a claim, a document, or a presentation. Plaint and written statement. Service of summons in special. Of which a suit is instituted. Its object is to state the grounds upon which the assistance of the court is sought by the plaintiff. It is a pleading of the plaintiff. Plaint is a suit instituted. Its object is to state the grounds upon which the assistance of the court is sought by the plaintiff. It is a pleading of the plaintiff. Particulars to Rule 18. Every plaint should contain the following particulars: the name of the court in which the suit is brought, name and description and place of residence of the plaintiff, name, description, place of residence of the defendant, where the plaintiff or defendant is a minor or a person of unsound mind, a statement to that effect, facts constituting the cause of action when it arose, facts showing that the court has jurisdiction, a statement of value of the subject matter of the suit for the purpose of jurisdiction and court fees, reliefs claimed by the plaintiff simply or in the alternative, whereas the plaintiff files a suit in a representative capacity, facts showing that the plaintiff has an actual existing interest in the subject matter, that he has taken steps that may be necessary to enable him to file such a suit, where the plaintiff has allowed a set-off or relinquishment a portion of his claim, the amount so allowed or relinquished, where the suit is for recovery of money, the precise amount claimed, where the suit is for accounts for mesne profits or for movables, or in the possession of the defendant, or for debts which cannot be determined, approximate amount and value thereof. Where the subject matter of the suit is immovable property, a description of the property is sufficient to identify, example, boundaries, survey numbers, the interest and liability of the defendant in the subject matter of the suit, where the suit is time-barred, ground upon which the exemption from the law of limitation is claimed. Let us consider some important aspects in detail. Parties to suit. There must be two parties in every suit, namely the plaintiff and defendant. There may, however, be more than one plaintiff or more than one defendant, but there must be at least one plaintiff and one defendant in every suit. All particulars such as name, father's name, age, place of residence which are necessary to identify the party must be stated in the plaint. Cause of action. Every suit presupposes the existence of a cause of action against the defendant, because if there is no cause of action, the plaint will have to be rejected. Even though the expression cause of action has not been defined in the code, it may be described as a bundle of essential facts which it is necessary for the plaintiff to prove before he can succeed, or which give plaintiff the right to relief against the defendant. Thus, cause of action means every fact which is necessary to establish a support, a right, or to obtain a judgment. To put it differently, cause of action gives occasion for and forms the foundation of the suit. The classic definition of the said expression is found in a case of Cookie versus Gill, wherein Lord Brett observed, cause of action means every fact which it would be necessary for the plaintiff to prove, if traversed, in order to support his right to the judgment of the court. Cause of action has nothing to do with the defense which may be set up by the defendant, nor does it depend upon the character of the relief prayed for by the plaintiff. It refers entirely to the ground set forth in the plaint as a cause of action, or in other words, to the media upon which the plaintiff asks the court to arrive at a conclusion in his favor. It must be antecedent to the institution of the suit, and on the basis of that cause of action, the suit must have been filed. Whether any particular facts constitute a cause of action has to be determined with reference to the facts of each case, taking into consideration the substance of the matter rather than the form of action. It is also necessary for the plaintiffs to state specifically which cause when such cause of action arose. This will enable the defendant as well as the court to ascertain from the plaint whether in fact and in law the cause of action as alleged by the plaintiff in the plaint did arise or not. In Kuldeep Singh versus Ganpat, Supreme Court observed the object underlying the Order 7 Rule 1E, which requires that the plaint shall contain the particulars about the facts constituting the cause of action, and when it arose, is to enable the court to find out whether the plaint discloses the cause of action because the plaint is liable to be rejected under Order 7 Rule 11 CPC if it does not disclose the cause of action. The purpose behind the requirement of the plaint should indicate when the cause of action arose is to help the court in ascertaining whether the suit is not barred by limitation. Any error on the part of the plaintiff is indicating the date on which cause of action arose would be of little consequence if the cause of action had arisen on the date on which the suit was filed and the suit was within limitation from the said date. Error in mentioning the date on which the cause of action had arisen in the plaint in such a case would not disentitle the plaintiff from seeking relief from the court in the suit. Thus, in a suit for possession against the tenant on the ground of non-payment of rent, the period for which the tenant has been in default must be stated. So also in a suit on a promissory note on demand, it must be stated that in spite of demand being made, no payment was made by the promissory defendant. Similarly, in a suit for damages for breach of contract, it must be stated that the contract was entered into between the plaintiff and the defendant, and that the defendant had committed breach thereof. Likewise, in a suit for specific performance of an agreement, the plaintiff must state that he was and is ready and willing to perform his part of the agreement. When the plaintiff seeks relief in respect of several distinct claims or causes of action founded upon separate and distinct grounds, he should state them as far as possible separately and distinctly. But for deciding whether the facts averred by the plaintiff would or would not constitute a cause of action partly or wholly, the court must consider whether such facts constitute material, essential, or integral part of the cause of action. If it is, it forms a cause of action, but if it does not form part of the cause of action. In determining the said question, the substance of the matter and not the form thereof has to be considered. It is no doubt true that even if a small fraction of a cause of action arises within the jurisdiction of the court would have territorial jurisdiction to entertain the suit. Nevertheless, it must be a part of cause of action, nothing less than that, jurisdiction of the court. The plaintiff must state all facts showing how the court has pecuniary and territorial jurisdiction over the subject matter of the suit. When the jurisdiction of a court to entertain the suit is disputed by the defendant, the court may frame the issue to that effect and decide the same before deciding other issues. That means jurisdiction first. Valuation. The plaintiff must state in the plaint the valuation of the subject matter of the suit for the purpose of pecuniary jurisdiction of the court and court fees. Sometimes the valuation of the subject matter for both the purposes may be the same, as for example in a suit for recovery of money, but sometimes two valuations may differ, as for example in a suit for declaration or in a suit for injunction or for possession of immovable property. In such a case, the plaintiff should distinctly state the valuation of the suit for the purpose of jurisdiction of the court and for the purpose of court fees. Limitation. Rule 6. Rule 6 provides that where the suit is barred by limitation, it is necessary for the plaintiff to show the grounds of exemption in the plaint. But the proviso added by the Amendment 76 empowers the court to permit the plaintiff rely on a new ground for exemption if it is not inconsistent with the grounds mentioned in the plaint. Relief. Rule 7 and 8. Every plaint must state specifically the relief claimed by the plaintiff, either simply or in the alternative. Where the relief is founded on a separate and distinct ground, they should so state. Where the plaintiff is entitled to more than one relief in respect of the same cause of action, it is open to him to claim all or any of such reliefs. But if he omits, except with the leave of the court, to sue for any particular relief, he will not afterwards be allowed to sue for the relief so omitted. It is not necessary to ask for general or other relief, but the general relief usually prayed for by the plaintiff in the plaint in the following terms. The plaintiff prays for such further or other relief as the nature of the case may require. Strictly speaking, this type of prayer is not necessary, since such relief may be granted by the court as if it has been asked for, provided it is not inconsistent with the specific claim raised in the pleading. Same rule applies to any relief claimed by the defendant in his written statement. The court must have regard to all the relief and look at substance of the matter and not at its form. As for example, prayer for costs need not be added in the plaint, since as a general rule costs follow the event, and the court is bound to decide the point. Similarly, in a suit for possession and mesne profits, the court can grant further mesne profits even if they are not specifically asked for. Plaintiff should state specifically the relief which he claims either simply or in the alternative. As stated above, it is open to the plaintiff to pray for an alternative relief even though it may be inconsistent, provided that it is maintainable and not prohibited by any law. Where a question arises as to whether the plaintiff has asked for a particular relief in his plaint, the plaint must be read as a whole, and the substance of the matter and not form thereof should be considered. In Bhagwati Prasad versus Chandramouli, Supreme Court explained the principle thus. General rule, no doubt, is that the relief should be founded on pleadings made by the parties, but where the substantial matters relating to the title of both parties to the suit are touched, though indirectly or even obscurely, in the issues and the evidence has been led about them, then the argument that a particular matter was not expressly taken in the pleadings would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such objection is, did the parties know that the matter in question was involved in the trial, and did they lead evidence about it? If it appears that the parties did not know that the matter was an issue at the trial, and none of them had no opportunity to lead evidence in respect thereof, that undoubtedly would be a different matter. To allow one party to rely upon a matter in respect of which the other party did not lead evidence and has had no opportunity to lead evidence would introduce considerations of prejudice, and doing justice to one party, court cannot do injustice to the another. The suit cannot be dismissed merely on the ground that the plaintiff has claimed a larger relief than he is entitled, but the lesser relief to which the plaintiff is entitled will be granted in his favour by the court on its own. But the court cannot grant a larger relief to the plaintiff than that claimed by him, even if it is entitled to it, unless he gets his plaint amended with the leave of the court. Events happening after institution of the court suit. The basic rule is that rights of the parties should be determined on the basis of the date of filing of the suit. Thus, where the plaintiff has no cause of action on the date of filing of the suit, he will not ordinarily be allowed to take advantage of the cause of action arising subsequent to the filing of the suit. So, similarly, no relief will be refused to the plaintiff by reason of any subsequent event if at the date of the institution of the suit he has substantive right. This, however, does not mean that no events happening after the institution of the suit can be taken into account at all. In appropriate cases, it is not only right but the duty of the court to consider the change in circumstances, where it is shown that the original relief claimed by the plaintiff has, by reason of subsequent change in the circumstances, become useless or inappropriate, or where it is necessary to take notice of the change in circumstances, shorten litigation. A new relief may serve the purpose better, or that a relief is required to be reshaped or molded in the light of change in facts, or in law to do full and complete justice between the parties. The court is bound to depart from the above rule and mold the relief in the light of altered circumstances. In Amarjit Singh versus Khatun Kumarain, the Supreme Court observed, administration of justice demands that any change, either in fact or in law, must be taken cognizance of by the court, but that must be done in a cautious manner of relevant facts. Therefore, subsequent events can be taken cognizance of if they are relevant and material. In the leading case of Possibility Venkateshwarlu versus Motor and General Traders, Krishna Iyer, J. propounded, it is basic to our processual jurisprudence that the right to relief must be judged to the extent as on the date a suitor institutes the legal proceeding. Equally clear is the principle that the procedure is handmade and not the mistress of the judicial process. If a fact arising after the list has come to the court and has a fundamental impact on the right to relief or a manner of molding it, is brought diligently to the notice of the tribunal, it cannot blink at it nor be blind to events which justify or render inept the decretal remedy. Equity justifies bending the rules of procedure where no specific provision or fair play is violated, with a view to promote substantial justice, subject of course to the absence of other disentitling factors or just circumstances. Nor can the court contemplate any limitation on this power to take note of updated facts, to confine it to the trial court. If the litigation pends, the power exists and absent of other special circumstances, repelling resort to the court of law or justice. Rulings on this point are legion, even as situations for application of this equitable rule are myriad. We affirm the proposition that for making the right or remedy claimed by the party just and meaningful, as also legally and factually in accord with the current realities, the court can, in many cases, must take cognizance of events and development subsequent to the institution of proceeding, provided the rules of fairness for both sides are scrupulously obeyed. It is submitted the following observations of Ramji Lal versus State of Punjab lay down correct law on the point are therefore worth quoting. It is true that courts do very often take notice of events that happen subsequent to the filing of suits, and at times even those that have occurred during the appellate stage, and permit pleadings to be amended for including a prayer for relief on the basis of such event, but this is ordinarily done to avoid multiplicity of proceedings, or when the original relief claimed has, by reason of change in circumstances, become inappropriate, and not when the plaintiff's suit would be wholly displaced by the proposed amendment, or a fresh suit by him would be so barred by limitation. Thus, where during the pendency of a suit for permanent injunction the plaintiff is dispossessed by the defendant, court can grant relief for restoration of possession also. Similarly, in a suit of partition by A against his brothers B and C, if C dies, A can claim 1/2 share instead of 1/3. Again, where the proceedings under the Rent Control Act or permission to evict a tenant were pending subsequent events affecting the right of the landlord to evict have been taken into account even in revision. So also pending an appeal in the Supreme Court, the defendant, head of the Mutt, who nominated the plaintiff as his successor, died. Supreme Court took notice of that event and declared the plaintiff as the successor of the defendant, under the will alleged to have been revoked by the deceased defendant, but where the rights of the parties have already been crystallized and the decision reached finality, including controversy, cannot be reopened on the basis of subsequent events by divesting a party of the benefit of the right which accrued to him. Admission of plaint. Rule 9. Rule 9 lays down the procedure where the plaint is admitted by the court. It provides for filing copies of the plaint by the plaintiff and also requires him to pay requisite fees for service of summons on the defendants within 7 days. Return of plaint. Rules 10 and 10b. Where at any stage of the suit the court finds it has no jurisdiction, either territorial or pecuniary, or with regard to the subject matter of the suit, it will return the plaint to be presented to the proper court in which the suit ought to have been filed. Rule 10a prescribes the procedure to be followed by a court before the plaint is ordered to be returned to be presented to the proper court. It is inserted to obviate the necessity of serving the summons on the defendants where the return of the plaint is made after the appearance of the defendants in the suit. An appellate court can also return the plaint to be presented to the proper court. Judge returning the plaint should make endorsements on it regarding one, date of presentation, date of return, name of the party presenting, and the reasons for returning. But at the stage of consideration of return of plaint, averments in the plaint alone should be looked into. Moreover, the plaint should be read in a meaningful manner and as a whole so as to find out the real intention behind the suit. When the plaint is filed in the proper court after getting it back from the wrong court, it cannot be said to be a continuation of the suit, and the suit must be deemed to commence when a plaint is filed in the proper court. The order returning the plaint is appealable. 1. Rejection of the plaint. Rule 11. The plaint will be rejected in the following cases. 1. Where the plaint does not disclose the cause of action. If the plaint filed by the plaintiff does not disclose any cause of action, the court will reject it. But in order to reject the plaint on this ground, the court must look at the plaint and nothing else. The power to reject a plaint on this ground should be exercised only if the court comes to the conclusion that even if all the allegations set out in the plaint are proved, the plaintiff would not be entitled to any relief. In that case, the court will reject the plaint without issuing summons to the defendant. The reading of the plaint should be meaningful and not formal. But where the plaint does not disclose cause of action, clever drafting, ritual of repeating words, or creation of an illusion cannot insert a cause of action in a plaint. Again, there is a difference between a plea that the plaint does not disclose a cause of action and a plea that there is no cause of action for instituting a suit. For determining whether the plaint discloses the cause of action or not, averments in the plaint alone are relevant and material. Finally, the plaint can be rejected as a whole if it does not disclose the cause of action. A part of it cannot be rejected where relief claimed is undervalued. Where the relief claimed by the plaintiff is undervalued and valuation is not corrected within the time fixed and extended by the court, the plaint will be rejected. In considering the question whether the suit is properly valued or not, the court must confine its attention to the plaint only, should not look at other circumstances which may subsequently influence the judgment of the court as to the true value of the relief played for, where plaint is insufficiently stamped. Sometimes the relief claimed by the plaintiff is properly valued, but the plaint is written upon an insufficiently stamped paper, and the plaintiff fails to pay the requisite court fee within the time fixed or extended by the court. In that case, the plaint will be rejected. However, if the requisite court fee is paid within the time extended by the court, the suit or appeal must be treated as instituted from the date of presentation of the plaint, that is back time, or memorandum of appeal for the purpose of limitation as well as payment of court fee. If the plaintiff cannot pay the court fee, he may apply to continue the suit as an indigent person or a pauper. Where suit is barred by law. Where the suit appears from the statements in the plaint to be barred by any law, the court will reject the plaint. For instance, where in a suit against the government, the plaint does not state that a notice as required under Section 80 of the Code has been given to the government, the plaint will be rejected under this clause. But where a waiver of such notice is pleaded, the court cannot reject the plaint without giving the plaintiff an opportunity to establish that fact. Likewise, if the plaint itself shows that claim is barred by limitation, the plaint can be rejected. But if the question of limitation is connected with the merits of the case, the matter requires to be decided along with other issues, where the plaint is not a duplicate. Plaint has to be filed in duplicate. If the said requirement is not complied with, the plaint will be rejected, where there is no non-compliance with the statutory provisions. Where the plaintiff failed to comply with the provisions of Rule 9, plaint will be rejected. Other grounds. Grounds for rejection of the plaint include Rule 11, Order 7 is not exhaustive. On the other hand, relevant grounds, also a plaint can be rejected. Thus, if a plaint is assigned by a person not authorized by the plaintiff, and the defect is not cured within the time granted by the court, the plaint can be rejected. Likewise, where the plaint is found to be vexatious or meritless, not disclosing a clear right to sue, the court may reject the plaint under this rule. Procedure on rejected plaint. Rule number 12. Where a plaint is rejected by the court, judge will pass an order to that effect and will record reasons for such rejections. Next, effect of rejection of plaint. Rule 13. If the plaint is rejected, or any of the above grounds, the plaint is not thereby precluded from presenting a fresh plaint in respect of the same cause of action. Appeal. An order rejecting the plaint is deemed to be decree within the meaning of Section 2, Clause 2 of the Code and therefore is appealable. Documents relied on the plaint. Rules 14 and 17. Rule 14 to 17 deal with the production of documents by the plaintiff. Rule 14 enjoins the plaintiff to produce at the time of presentation of a plaint copies of all documents on which he sues or seeks to rely. It also provides the consequences of non-production of document. It lays down that a document which ought to be produced in the court by the plaintiff when the plaint is presented ought to be entered in the list to be added or annexed to the plaint, and is not produced or entered accordingly, and shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. The object underlying Rule 14 is to exclude the production of documents of a doubtful nature at a later stage. The court has wide discretion to allow or disallow production of documents at a later stage, having regard to the fact and circumstances of each case. This provision, however, does not apply to the following documents. 1. Document reserved for purpose of cross-examination of the defendant's witness, or documents handed over to a witness merely to refresh his memory. Agents and pleaders. Order 3. Appearance of parties. Rule 1. Generally, any appearance, application, or act are in or to any court may be done or made or done by a party in person or by his agent or a pleader appearing. Applying, acting on his behalf. No doubt, a court can direct any party to appear in person except for reasons. However, court will not direct the party to appear in person. Once such direction is issued by a court, even then the party fails to appear, the court may dismiss the suit or proceeding ex parte. The primary object of Rule 1 is to facilitate the proceedings of the court, to afford an opportunity to the party, and to enable him to perform certain acts through recognized agent or pleader which otherwise he would have to perform. Recognized agents. Rule 2. Agent meaning. An agent is a person having express or implied authority to effect on behalf of another person. Its principle. Recognized agent is a person allowed to speak or conduct proceedings in a court of law. Recognized agents under CPC. Following persons have been considered as recognized agents by the court: person holding power of attorney, person carrying on trade or business for parties, person specially appointed by the government to prosecute or defend on behalf of foreign rulers. Persons authorized to act as government. Pleaders. Rule number 4. Pleader definition. Pleader is defined in the court as any person entitled to appear and pleaded for another in the court, includes an advocate, a vakil or attorney of a high reputation. Appointment of pleader. Rule 4. Rule 4 prescribes the manner of the appointment of a pleader and also the limit to which such appointment remains in force. It provides that a pleader can be appointed by a document in writing known as Vakalat Nama and Vakalat Patra, signed by the party or by his recognized agent or by some other person duly authorized by him. Every such appointment shall be filed in the court and deemed to be in force until determination of all proceedings in the suit, or until determined by the client of the pleader, not until the client or pleader applies, or until duration for which is engaged over. Suitors of pleader. A legal profession is a strictly service-oriented profession. The ancestor of today's lawyers was a spokesman who rendered service to the needy members of the society without regard to remuneration. Relationship between a lawyer and his clients is of trust and confidence. Being a responsible officer of the court, the lawyer owes responsible conduct not only to his client but also to the other side and to the court and to society at large. He is essentially an advisor to his client and is likely called counsel in some jurisdiction. He demeans himself if he acts merely as a mouthpiece of his client. Authority of the pleader. A pleader stands on the same footing in regard to authority to act on behalf of the clients. There is inherent in the power of position of counsel as implied authority to do all that is expedient, proper and necessary for the conduct of the suit and settlement of disputes. This power, however, must be exercised bona fide and for the benefit of his client. Secondly, power is one thing and prudence is another. Indeed, sometimes based upon the latter, sometimes based upon the former. The lawyer must be above board, especially if he is to agree to an adverse verdict. It is prudent and proper to consult his client and take his consent if there is time and opportunity. He should not act as implied authority, except when warranted by exigency to the circumstance. The signature of the party cannot be obtained without undue delay. In these days of easier, quicker communication, such contingency may seldom arise again. Ordinarily, when a junior and a senior appear in the case, it will be risky on the part of the junior to report a compromise without consulting his senior. Duties of pleader. Lawyers are custodians of civilization. They have to discharge their duties with dignity, decorum, and discipline. They are not mere agents of their clans, but are officers of the court, and they are expected to assist in the administration of justice. As it is said in a council, as a tripartite relationship, one with the public, other with the court, that with the client. That is a unique feature of 112. Other professions or callings may include one or two of their relationships, but no other. Triple duty. Counsel's duty to the public is unique in that he has to accept all work from all clients in courts in which he holds himself as practicing. However, unattractive the case or his client. A counsel has the duty and right to speak freely and independently without fear of authority, without the fear of judges, and without fear of a stab in the back from his own client. To some extent, he is a Minister of Justice. 14. A counsel has no right to go on strike or remain absent from the court when the case of his client comes up for hearing. He is duty bound to attend the case in the court or to make an alternative arrangement. The mere fact that he was busy in some other client is not a good and sufficient ground for his non-appearance. In the court, when his case is called for hearing, such absence is not only fair to his client but also unfair and discourteous to the court and should be severely discountenanced. Lord Atkin rightly states the advocate is to conduct the cause of his client to the utmost skill and understanding. He must be in his interest that his client is a position hour by hour, almost minute by minute, to advance his argument, to withdraw that. He must make the final decision on whether evidence is to be given, not in the question of fact. Skill in advocacy is largely result of discrimination. Often the decision must be made at once. There are a few black sheep in every profession, nay, in every walk of life, but few as they are, they tarnish the fair image of age-old institution. The bar must sternly screen to extirpate the black scene. The Caesar's wife must be above suspicion. If the profession is to command the confidence of the community and the court, it is also the duty of lawyers to protect the dignity and decorum of judiciary. Lawyers fall in their duty, fail in their duty. The faith of people in judiciary will be undermined to the large extent. Responsibilities of pleader. No one expects a lawyer to be subservient to the court while pleading the presentation of his client and not to put forward his arguments merely because the court is against him. On the contrary, that is the moment when he is expected to put forth and his best efforts to persuade the court, but if the lawyer finds, in spite of his efforts, that the court is against him, he should not be discourteous to the court, nor should he be disrespectful and derogatory language. The lawyer is not entitled to indulge in upcoming conduct either by shower or temper or using unbecoming language. In the legal profession is a solemn and serious occupation. It is a noble calling, and all those who belong to it are its honorable members, although the entry to the profession can be had by acquiring merely the qualification of technical competence. The honor as a profession has to be maintained by its members of their exemplary conduct both in and outside the court. The legal profession is different from that profession in that what the laws do affects not only an individual but also the administration of justice, which is the foundation of civilized society. Both as a leading member of the intelligentsia of the society and a responsible citizen, the lawyer has to conduct himself as a model for others, both in his profession and in his private and public life. The society has a right to expect of him such ideal behavior. Strike by pleaders. A lawyer or a pleader cannot go on strike nor boycott a court. It is the duty of every lawyer to attend trial, even if it may go on for a prolonged period. He cannot refuse to attend the court on the ground that the Bar Association or the Bar Council has given a call for strike and boycott of the court. A court also cannot adjourn matters merely because lawyers are on strike. If the lawyers resort to strike, they are answerable for consequences. Only in the rarest of rare cases involving dignity, integrity, and independence of the bar or the bench, the abstention court work may not be taken seriously. But it is the court to decide whether the issue calls for such action. Normally, in such a case, the president of the bar should first consult the chief justice or the district judge whose decision is final. While listen, we have to take out. Appearance by proxy. It is a recognized practice in almost all courts that the counsel or parties are allowed to be represented by the other counsel. Representations made by them are usually taken as representation by the counsel on record unless it is shown otherwise. Service of process, rules 3 and 56. A process served on the recognized agent or a pleader of the party or left at the office or residence of the pleader will be considered as a valid and proper service. Summons, section 27 to 29, order 5. Summons, meaning when the plaintiff files a suit, the defendant has to be informed that the suit has been filed against him and that he is required to appear in the court to defend it. The intimation which is sent to the defendant by the court is technically known as summons. Though the said expression summons has not been defined in the code according to the dictionary meaning, summons is the document issued from office of a court of justice calling upon the person to whom it is directed to attend before a judge or an officer of the court for certain purposes. Object of issuing summons. When a court is filled with plaintiff against the defendant and relief is claimed, the defendant must be given an opportunity as to what he has to say against the prayer made by the plaintiff. Thus, in accordance with the principle of natural justice, as no one could be condemned unheard adi alteram partem. If the defendant is not served with the summons, a decree passed by against him is not binding. Essential summons, route 12. Every summons has to be signed by the judge or such officer appointed by him and shall be sealed with the seal of the court. It must be accompanied by a plain form of summons. Every summons should be in the form prescribed in Appendix B to the first schedule of the court. Summons to defendant. Section 27, Order 5, Rule 1. Order 5 deals with summons to a defendant, while the Order 16 deals with summons to witnesses. When a suit has been duly filed by the presentation of a court must issue summons to the defendant, calling upon him to appear and answer the claim of the plaintiff by filing a written statement within 30 days from the date of service of summons. No summons, however, will be issued by the court if, at the time of presentation of a plaint, the defendant is present and admits the plaintiff's claim. Appearance in person, Rule 3. A defendant to whom a summons has been issued may appear 1. In person, 2. In pleader, duly instructed and able to answer all material questions relating to the suit, and 3. By a pleader accompanied by some person able to answer all such questions. The court, however, may order the defendant or plaintiff to appear in person. Exemption from appearance in person. 13(2), 33 and Rule 4. No person shall be ordered to appear in person unless he resides A. within the local limits of the court or ordinary or original jurisdiction, or such limits but at a place less than 50 miles or 200 miles where public conveyance is available from the out, or who is a woman not appearing in public, or who is entitled to exemption under the code. Contents of summons rule. The summons must contain a direction whether the date fixed is for settlement of issues or for final disposal of the suit. In the latter case, the defendant should be directed to produce his witnesses. The court must give sufficient time to the defendant to enable him to appear and answer the claim of the plaintiff is the day fixed. Summons should also contain an order to the defendant to produce all documents or copies thereof in his possession or power up to which he intends to rely on in support of his case. Mode of service of summons, Rule 230. The service of summons is of primary importance as it is a fundamental rule of law procedure that is party have a fair and reasonable notice is good in proceedings initiated against him so that he can defend himself. The problem of service of summons is one of the major causes of delay in the progress of the suit. It is common knowledge that the dereliction tried to avoid suit of service of summons. The Law Commission considered the problem and it was felt that certain amendments were necessary in the direction a defendant can be served by a plaintiff or through modern means of communication. Accordingly, amendments were made in Code 76/99/2002. Code prescribes the 5 principles moved by serving summons to a defendant. 1. Personal or direct service, Rule 10-16. Rule 10 to 16 and 18 deal with the personal and indirect service of summons upon the defendant. This is an ordinary mode of service of summons. Here, the following people must be remembered. Wherever it is practicable, the summons must be served to the defendant or in person or through his legalized agent. Where the defendant is absent from his residence in the period of service of summons and the likelihood of him being found at his residence within a reasonable time and he has no authorized agent, summons may be served on any adult male or female member of the defendant family residing with him. A servant, however, cannot be said to be a family member. To a suit relating to any business work or a person residing within the territorial jurisdiction of the court issuing summons, it may be served to the manager or agent carrying on such business or work. In a suit for immovable property, if the service of summons cannot be made of the defendant personally and the defendant has no authorized agent, the service may be made on any agent of the defendant in charge of the property. Where there are 2 more defendants, the service of summons should be made on each of the defendants. In all the above cases, service of summons should be made by delivering or tendering a copy thereof. Where the serving officer delivers a copy of summons to be defendant personally or to his agent or other person on his behalf, the person to whom the copy is delivered and tendered must make an acknowledgement of service and summons. Serving officer thereafter must make an endorsement on the original summons, taking the time and manner of service written and the name and address of the properties, if any, identifying the person perceived witnessing the delivery and such tender age. Summons to defendant residing within the jurisdiction of the court shall be served through court officer or Amina or approved courier service. Summons can also be served by registered post, speed post, acknowledgement due, courier service, fax, message, email service, any other permissible means transmission. Where the defendant is residing outside the jurisdiction of the court, the summons shall be served through an officer of the court within whose jurisdiction the defendant resides. The court shall treat refusal or acceptance as a valid service. Where summons is properly addressed, prepared and duly sent to registered and post acknowledgement due, there will be a presumption of valid service summons even in the absence of an acknowledgement slip. Though there can be no injunction in giving an opportunity for the plaintiff to serve summons on the defendant, there should be sufficient safeguards to avoid false report of service summons. High Court should make appropriate rules of practice and directions to ensure that the provisions are properly implemented and there is no doubt. The court prescribes the principal mode of serving summons to a defendant: personal and direct service. Rule 10 to 16 and 18 deal with the provisional direct service of summons upon the defendant. There is an ordinary mode of service of summons. Here the following principles must be remembered. Wherever it is practicable, summons must be served to the defendant in person or to his authorized agent. Where the defendant is absent from his residence at the time of service of summons and there is no likelihood of him being found at his residence within a reasonable time and he has no authorized agent, the summons may be served on any adult male or female member of the defendant's family residing with him. A servant, however, cannot be said to be a family member. In a suit relating to any business or work against a person not residing within the territorial jurisdiction of the court issuing summons, it may be served to the manager or agent carrying on such business work. In a suit for immovable property, if the service of summons cannot be made on the defendant personally and the defendant has no authorized agent, the service may be made on any agent of the defendant in charge of the property. Where there are two or more defendants, service of summons should be made on each defendant. In all the above cases, service of summons should be made by delivering or tendering a copy thereof, where the serving officer delivers or tenders a copy of the summons to the defendant personally or to his agent or other person on his behalf. The person to whom the copy is delivered or tendered must make an acknowledgement of the service of summons. The serving officer thereafter must make an endorsement on the original summons stating the time and manner of service thereof and the name and address of the person, if any, identifying the person served and witnessing the delivery or tender of summons. Service by court. Rule 9. Summons to a defendant residing within the jurisdiction of the court shall be served through court officer and approved courier service. Summons can also be serviced by registered post, speed post, acknowledgement due, courier service, fax, message, email service, any other permissible means of transmission. Where the defendant is residing outside the jurisdiction of the court, the summons shall be served to an officer of the court within whose jurisdiction the defendant resides. Court shall treat refusal to acceptance as a valid service. Where summons is properly addressed, prepaid and duly sent by registered post, acknowledgement due, there will be a presumption of valid service of summons even in the absence of an acknowledgement slip. Though there can be no objection in giving an opportunity to the plaintiff to serve summons on the defendant, there should be sufficient safeguards to avoid false report of service of summons. High Court should make appropriate rules or issue practical suggestions to ensure that the provisions are properly implemented and thus there is no abuse of process of law. Service by plaintiff. Rule 9a. The court may also permit service of summons by the plaintiff in addition to the service of summons by the court. Substituted service. Rule 17, 19 and 20. Substituted service means the service of summons by a mode which is substituted for the ordinary mode of service. There are two modes of substituted service. They are one where the defendant or his agent refuses to sign the acknowledgement, or where the serving officer, after due and reasonable diligence, cannot find the defendant who is absent from his residence at the time of service of summons and there is no likelihood of being found at his residence within a reasonable time and there is no authorized agent or any other person or service can be made. Service of summons can be made by affixing a copy on the outer door of some other conspicuous part of the house in which the defendant ordinarily resides or carries on business or personally works for gain. The serving officer shall then return the original to the court from which it is issued with the report endorsed thereon stating the fact about affixing the copy, circumstances and rules read so, and the name and address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. In the court is satisfied either on the affidavit of the serving officer or on his examination and oath that summons have been duly served and make further inquiry in the matter as it thinks fit. Thus, in the second mode of service of summons, as provided by Rule 17, the service is effected without an order of the court by affixing a copy of the summons on the house of the defendant. Therefore, the declaration by the court about the due service of summons is essential. If the provision of Rule 19 have not been complied with, the service of summons cannot be said to be in accordance with law. Where the court is satisfied, there is reason to believe that the defendant avoids service or for other reason summons cannot be served in the ordinary way. Service may be effected in the following manner: by affixing a copy of the summons in some conspicuous place in the courthouse, also upon some conspicuous part of the house in which the defendant is known to have last resided, carried on business or personally worked for gain, and two, in such a manner as the court thinks fit. It, however, must be remembered that this is not a regular mode of service and hence it should not normally be allowed and can be effected only as a last resort. Before more than a century ago, in Cohen versus Narsingh Das, it was stated, "It is true that you may go to a man's house and not finding him, and that is not attempting to find him. You should go to his house, make inquiries, and if necessary, follow him. You should make inquiries to find out when he is likely to be at home, and go to the house at a time when he can't be found. Before service like this can be effected, it must be shown that the proper efforts have been made to find out when and where the defendant is likely to be found. Not, as seems to be done in this country, to go to his house in a perfunctory way, because he has not been found there, to affix a copy of the summons on the outer door of this house, where the court orders service by an advertisement in a newspaper. The newspaper should be daily newspaper circulating in the locality in which the defendant is not known to have actually resided. Such service is effective service even if the defendant is not the subscriber of the newspaper or is not reading it. Under Rule 20, service of summons is effected by an order of the court only after the court is satisfied satisfied that the defendant avoids service of summons, nor it cannot be served in the ordinary way. Such satisfaction must be recorded by the court in writing. Substitute service is effective personal service. The court must fix a time for the appearance of a defendant and give him a reasonable time to appear before the court. Service by post. When acknowledgement purporting to be signed by the defendant or his agent is issued by the summons, the defendant or his AG refused to take delivery of the summons when tendered to him. The court asking the summons shall declare that summons had been duly served on the defendant. 171. Same principle applies in the case where the summons were properly addressed, prepaid and duly sent by registered post acknowledgement to, and the acknowledgement is lost and not received by any court within 30 days from the date of issue of the summons. Where the summons sent by registered post is returned with endorsement refused, the burden is on the defendant to prove that the endorsement is false. Refusal of summons. Where the defendant refuses to accept summons, he is deemed to have been served. Similarly, an acknowledgement or receipt purported to have been signed by the defendant or agent is issued by the court. The defendant or his agent has refused to take delivery of the summons. The court will proceed treating the defendant as served. Objection as to service of summons. An objection as to the service of summons should be raised at the earliest possible opportunity. If it is not taken at this stage, deemed to have been waived. Service of summons in special cases, Rule 21 to 30. Where the defendant resides where the jurisdiction of another court or in another state, the summons may be sent to the court where he resides. Such court will serve the summons on the defendant. Service of foreign summons may be effected by sending them to the court in the territories in which the provisions of this court apply and served as if they were summons issued by such court. Where the summons is to be served within the presidency towns of Bombay, Maharashtra, Calcutta, it may be sent to court of small causes within whose jurisdiction it is to be served. Where the defendant resides out of India and has no authorized agent in India to accept service, summons should be addressed to the defendant and the place are where he is residing or sent to him by post, courier or fax or electronic mail or any other appropriate means. If there is a portal, communication between such place and place where the court is situated. Where the defendant resides in a foreign country, the service of summons may be effected through the authority to serve the summons. Where the defendant is a public officer, not belonging to Indian military, naval or air force, or is a servant of the railway company or local authority, summons may be served through the head of the department in which the defendant is employed. Next. When the defendant is a soldier, sailor, airman, the court shall send summons for service to the person commanding him. Where the defendant is in prison, service of summons is to be made on the officer in charge of the prison. Where the defendant is a corporation, summons may be served on the secretary or on any director or other principal officer of the corporation, or by leaving it or sending it by post addressed to expiration of the registered office. If there is no registered office, then at that place where the corporation carries on business. Where the defendant are primary partners in the firm, summons should be served upon any one or more of the partners, upon one person carried on control management of the partnership, because at that place of principal business. But if the plaintiff knows partnership firm has not dissolved before the institution of the suit, summons shall serve upon every person sought to be liable in India. Though the expression written statement order 8, though the expression written statement has not been defined in the code, a term of specific connotation ordinarily signifying a reply to the plaint filed by the plaintiff as the return. Thus, the expression written statement has not been defined. It is a term of specific connotation ordinarily signifying a reply to the plaint filed by the plaintiff. In other words, the written statement in the pleading of the general defendants wherein he deals with every material fact alleged by the plaintiff in his plaint, and also states any new facts in his favor or next and also states any new fact in his favor or takes cognizable objection against the claim of the plaintiff. Who may be filed written statement? A written statement may be filed by the defendant or his duly constituted agent. Where there are several defendants, a common written statement is filed by them. It must be signed by all of them. It is however sufficient if it is verified by one of them who is aware of the facts of the case and is in a position to file an affidavit. But in a written statement filed by one defendant does not bind all other defendants. When written statement may be filed, a defendant should, within 30 days from the service of summons, present a written statement on his defense. The said period, however, can be extended up to 90 days with the permission of the court. Outer limit for filing written statement. Proviso to Rule 1 as inserted in Amendment 2002 prescribes the outer limit of 90 days of filing written statement from the date of service of summons on the defendant. In Kailash vs. Nanku, Supreme Court were called upon to consider whether the time limit of 90 days prescribed by the proviso of Rule 1 or 8 for filing written statement by the defendant was mandatory or merely directory. Considering the provision of the Code as originally enacted, recommendations of the Law Commission, anxiety of the Parliament to ensure speedy disposal of cases, but without sacrificing fairness of trial and principles of natural justice inbuilt in all procedural laws, the Court held the provision directory and permissive and not mandatory and imperative. The process of justice may be sped up or hurried, but the fairness, which is the basic element of justice, cannot be permitted to be buried. The Court rightly stated all the rules of procedure are 100 minutes of justice. Language employed by the draftsman of process law may be liberal or stringent, but the fact remains that the object of prescribing procedure is to advance the cause of justice. In an adversarial system, no party should ordinarily be denied the opportunity of participating in the process of justice dispensation unless compelled by express or specific language of the statute. Provisions of CPC or any other procedural enactment ought not to be construed in a manner which would leave the court helpless to meet extraordinary situation in the hands of justice. The court concluded merely because the proviso of law is couched in a negative language implying mandatory character, and the same is not without exception. The courts, when called upon to interpret the nature of the provision, may, keeping in view the entire content in which the provision came to be enacted, hold the same to the factory, directing through word in the native form. In the leading decision of Salem Advocate Bar Association versus Union of India, harmoniously construing the Rule 1, 9, 10 of Order 8, the Supreme Court observed, in construing this provision, support can also be drawn from the Order 8, Rule 10, which provides that where any party from whom a written statement is required under Rule 1 and Rule 9 fails to present the same within the same period or fixed by the court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit. On the failure of to write a statement under this provision, the court has been given the discretion either to pronounce judgment against the defendant or to make such an order in relation to suit as it thinks fit as the context of the provision despite the word shall. And the court has been given the discretion to pronounce or not to pronounce the judgment against the defendant, even if written statement is not filed or instead of pass such orders as it may think fit in relation to the suit. In construing the provisions of the Order 8, Rule 1 and Rule 10, the doctrine of harmonious construction is required to be applied. Either would that be in Rule 10 of the order, the court in its discretion would have power to allow the defendant to file written statement even after the expiry of period of 90 days prescribed in the Order 8 rule. There is no restriction on Order 8 Rule 10 that after expiry of 90 days further time cannot be granted. Court has wide power to make such orders in relation to the suit as it is thinks fit. Clearly, therefore, the provision of Rule 1 providing for upper limit of 90 days in the file of written statement is directory. Having said sorry. Exceptionally hard cases. Time can be extended only in case of exceptionally hard cases. While extending time, it has to be borne in mind that the legislator has fixed to the extent the time shall not be so frequently and routinely exercised so as to nullify the period fixed by the Order 8. Rule 1. Morality of justice at the hands of law troubles the judge's conscience and points an angry interrogation at the law enforcement. A written statement should be drafted carefully, artistically. All the general rules of pleadings discussed in Chapter 6 apply to the written statement. Also, before proceeding to draft a written statement, it is absolutely necessary to examine the complaint carefully, and like a plaintiff, the defendant may also take a number of deficiencies, either simply or in the alternative, even though they may be inconsistent, provided they are maintainable as law and not embarrassing. Special rules of evidence. Over and above general defenses, Rule 2 to 5 and 7 to 10, deal with the special points regarding filling of a written statement. New facts such as suit is not maintainable, or the transaction is either void or voidable in the law, and all such grounds of defense as if not raised, would take the plaintiff by surprise or would raise issues of fact not arising out of the plaint, such as fraud, limitation, release, payment, performance. Facts showing illegality must be raised. The effect of the rule is, for the reasons of practice and justice convenience, to require the party to does not tell his opponent what he is coming to the court to prove. If he do not do that, court will deal with it. It may say that it is not open to him, but he has not raised and will not be allowed to rely on it. It may give leave to amend by raising it and protect the other party if necessary by letting the case stand over. The rule is not one that excludes from the consideration of the court the relevant subject matter for decision simply on the ground that it is not pleaded. It leaves the party at the mercy of the court, and the court will deal with him as a just emphasis. If the plea is broken, it may be lead plaintiffs to believe that the defendant has waived the right, but not again, if the plea or the ground of defense raises an issue arising out of an admitted fact and is otherwise apparent from the plaint itself, no question of prejudice or surprise to the plaintiff arises. This rule does not require the defendant to take such plea, nor debars him from setting up at a later stage of the suit when it does not depend on the evidence but raises a pure question of law, like plea affirmative. Similarly, where the defendant has stated in his pleadings all the facts on which he has basis his defense without stating the legal effect, thereto defense cannot be rejected on the ground the legal effect of the facts was not stated. Denial must be specific. It is not sufficient for a defendant to, in his written statement, to deny generally the grounds alleged by the plaintiff, but he must deal specifically with each allegation of the fact where he does not admit except the charges. 1947, 1948 time. The denial should not be vague or evasive. Where a defendant wants to deny an allegation of fact in the plaint, he must do so clearly, specifically, and explicitly, and not evasively or generally. Thus, it is alleged that he has received a certain sum of money and shall not be sufficient to deny that he received that particular amount of money, but that he must deny that he received that sum of money thereof, or else is set out to how much he received. Every allegation of the fact in the plaint, if not denied specifically or by necessary implication, are stated to be not admitted on the pleadings of the defendant, shall be required to take admitted, except as against a person under disability. The court may, however, require proof of any such act other on the basis of the facts stated in the plaint, or may require any such facts to be proved. If a judgment is pronounced by the court, the decree shall be drawn up in accordance with 12.2.06. The combined effect of rules 3, 4 and 5 can be considered by Subbarao. In the case of Badat and Company versus East India Trading Company, in the following verse, these three rules form an integral code dealing with the manners in which the allegation of the facts in the plaint should be traversed and the legal consequences flowing from its non-compliance. Written statement must deal specifically with each allegation of the fact in the plaint, and when a defendant denies any such fact, he must not do so evasively but answer the point of substance. It is denial of fact is not specific, but evasive said fact shall be taken into admitted. In such an event, the admission itself being proof, no other proof is necessary. A few illustrative cases will make the position very clear. In action where the lessee set aside the lease, the plaintiff alleges that in his plan, the defendant offered to the manager of the plaintiff a bribe of 5,000 for the defendant office on 15 January. And the defendant on his written statement stated that he did not offer to the plaintiff's manager a bribe of 5,000 in the defendant office on 15 January. Denial is evasive. Here the point of substance is that the bribe was offered neither day or the amount, and that is not met. The defendant might have offered any other amount or any other day at a different place. Since the point of substance is the offer of bribe, it must be clearly, specifically denied, and the defendant should state that he never offered a bribe of 5,000 or of any other sum on any day at any place to the plaintiff's manager as alleged or at all. Similarly, if the plaintiff asserts the defendant broke and entered into the shop of the plaintiff and seized and carried away all the furniture, stock in trade, other effects which were therein, the correct traverse will be the defendant never broke or entered into the shop of the plaintiff or seized, took or carried away my own furniture, scientific trade, other effects which were attached therein. Again, where a compound diagram consisting of several distinct facts is made in the plaint and is intended to deny each of such facts, the single denial of the whole allegation should not be made. The defendant should break up the allegation into separate parts and deny each of them separately. For instance, if the plaintiff alleges the defendant took possession of the plaintiff's house and the defendant wants to deny both the allegation of having taken possession of the house as well as plaintiff's ownership of the house, he must do expressly by saying the defendant never took possession of the house, the said house is not the plaintiff. In single traverse, the defendant denies that they took possession of the plaintiff's house would not be specific, since it may mean that the defendant only denies having taken possession of the house arrest and not the ownership of the plant. Manual 211 page. But if the plaintiff makes good general allegation in the when the plaintiff alleges in the plaintiff the order of his removal from service relative to Article 14 15 of the Constitution of India, since he was arbitrarily picked up, the denial in the written statement of the allegation there had been a violation of Article 14 and 16 of the Constitution of India is sufficient. In the absence of particulars in the plaint, all that the defendant could do would be simply to deny that there had been discrimination. Again, express that numerical denial of particular area of the plaint is only a matter of form and not a substance. And it would be sufficient if the allegations made in the plaint have been specifically denied, even if denial of a particular area of a plaint is omitted in the defense. Moreover, old and traditional system of pleading has been given up as soon as Lord Denning at one time general denial was held insufficient and embarrassing. But it is not the position today. Sometimes the pleader denies, sometimes he does not admit he in every allegation, but when the phrase is used in all come back to the same, the allegation is to be regarded as if it was specifically set out in the traverse in Syria to ensure. If it is a traverse, no more no less, where the defendant relies upon 7 distinct grounds of defense. Any new ground of defense which has been arisen after the inspection of the suit and the presentation of the written statement claiming a set-off or counterclaim raised by the defendant or the plaintiff, as the case may be, in his written statement. Here, the cost of empowered to take notice of subsequent events. No pleading after the written statement of the defendant, other than by way of defense to a set-off or counterclaim, can file the court may allow any part to file his pleading upon such terms as it thinks fit. If the defendant fails to present his written statement within the time period or fixed by the court will pronounce the judgment against him and pass an order in relation to the suit as it thinks fit, and a decree will be drawn up according to the said judgment. The court, however, cannot proceed to pass its judgment blindly, because merely no written statement is filed by the defendant traversing the averment made by the plaintiff in his plaint. In Modula, India, Karmika Singh Dev, explaining the ambit and scheme of the Rule 1, 5 and 10, the Supreme Court observed Rule 1 merely requires the defendant should represent a written statement of his defense within the time permitted by the court. Raised by the defendant as the case may be in his written statement. Here the court is empowered to take notice of subsequent events. No pleading after the written statement of the defendant other than by way of defense to a set-off or counterclaim can be filed. The court may, however, allow any party to file his pleading upon such terms as thinks fit. If the defendant fails to present his written statement within the time period fixed by the court will pronounce the judgment against him or pass an order in relation to the suit as it thinks fit, and a decree will be drawn up according to such judgment. The court, however, cannot proceed to pass its judgment blindly because no written statement was filed by the defendant traversing the averment made by the plaintiff in his plaint. In Modula, India versus Kamakya Singh Dev, explaining the ambit and scheme of 1, 5 and 10 of the Order 8, Supreme Court observed Rule 1 merely requires that the defendant should present a written statement of his defense within the time permitted by the court. Rule 5-2, where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of the facts contained in the furious plaint, except where a person using under disability, but the court may, at its discretion, require any such fact to be proved. Again, under Rule 10, where any party from whom a written statement is required or fails to present the same within the time period or fixed by the government, the court shall pronounce a judgment against him or make such order in relation to the suit as it thinks fit. It will be seen that these rules are only permissive in nature. They enable the court in an appropriate case to pronounce a decree straightaway on the basis of the plaint and averments. The court shall pronounce judgment against him. It is obvious from the language of the rulers that it is still an option with the court court either to pronounce a judgment on the basis of the plaint against the defendant or to make such other appropriate order as the court may think fit. Therefore, there is nothing in these rules which makes it mandatory for the court to pass a decree in favor of the plaintiff straight away, because the written statement has not been filed. It is submitted the following observation to the Supreme Court in Balraj Taneja versus Sunil Madan and laid down the court law in the point concerning the relevant provisions of the orders 8 and 20 and revert to a leading decision of the court. The court stated, if the court has not to act blindly upon the statement, has not been filed with the defendant traversing the court set out by the plaintiff. In a case especially where the written statement has not been filed by the accident by the defendant, court should be little cautious in proceeding under Order 8 Rule 10 CPC. Before passing judgment against the defendant, must be to see that even if the facts set out in the plaint are treated to have been admitted, the judge cannot possibly be passed in favor of the plaintiff without regarding to prove any fact mentioned in the plaint. It is a matter of court satisfaction, and therefore only on being satisfied that there is no fact which needs to be proved on account of due inflation. Documents related to written statement. Rule 1. Take like a plaintiff. A defendant is also bound to produce all documents in support of his defense or claim for set-off or counterclaim which are in possession. If the defendant fails to produce them, they will not be received in evidence except with the leave of the court. This provision, however, does not apply to the following document. Document reserved for cross-examination of the plaintiff's witnesses are documents handed over to a witness mainly to refresh his memory. Set-off. Rule 6. Meaning, set-off means a claim set up against another. It is a cross claim which party offsets the original claim. It is an extension of debts of which two persons are reciprocally debtors to one another, by the credits of which they are reciprocally creditors to men. By adjustment, set off either wipes out or reduces the plaintiff's claim in the suit for recovery of money. Doctrine explained where in the suit for recovery of money by plaintiff the debtor defends that he has also written a claim some amount against Pakistan, the plaintiff, we can see set off in respect of said amount. The doctrine of set off may be termed as the extension of debt, of which the two persons are reciprocally creditors to one another by the creditors by which they are reciprocally creditors to one. Plea of set off. A plea whereby a defendant acknowledges the justice of the plaintiff's demand but sets up another demand of his own to counterbalance that of the plaintiff, either in whole or in part. Thus it is a reciprocal acquittal of debts between two persons. The right of a defendant is to claim set off. The right of a defendant to claim set-off has been recognized under Rule 6. It obviates the necessity of filing a fresh suit by the defendant. Illustration. Let us see a few illustrations to understand the doctrine. A bequeaths 2,000 rupees to B and appoints C as executor and residual legatee. B dies and D takes out administration to B's defects. C pays 1,000 as surety for D. When due C for legacy, Lee cannot set off the debt of 1,000 against the legacy, for neither C nor D fails the same character with respect to the legacy as they fail with respect to the payment of 1,000. A dies intestate in debt to B. C takes out administration to A's effect, and 8 buys part of the effect from the C in a suit of purchase of money by C. Against B, the latter cannot set off a debit against the price, for C fails two different characters, one the vendor, the other in the as a representative to A. A sues B on the bill of exchange. B alleges that A has wrongfully agreed to ensure B's goods and his event. The amount not being ascertained cannot be set off. A sues B on the bill of exchange. The amount not being ascertained. A sues B on a bill of exchange. B alleges A is wrongfully neglected to ensure B's goods and liable to return him in compensation when he claims to set off. The amount not being ascertained cannot be set off. A sues B on a bill of exchange for ₹500. B holds a judgment against A for ₹1,000. The two claims being those definite pecuniary demand may be set off. A sues B for compensation on account of trespass. B holds a promissory note of ₹1,000 from A and claims to set off that amount against any sum that A may receive in the suit, being B may do so, for as soon as A recovery, both sums are definitely pecuniary demands. 1. A and B, C. A for Saibal Alaf Kalki. C and B matter. C cannot set off a debt due to him by A alone. A sues B and C for 1,000 rupees. B cannot set off a debt due to him alone by A. A owes partnership firm B and C 1,000 rupees. B leaves, leaving C surviving A sues C for a debt of 1,500 due in present character. C may set off the debt of 1,000. A sues B for 20,000. B cannot set off for a claim of damage to breach of contract for specific performance. A sues B 10,000 rupees. B cannot sell off any amount due to him on a promissory note by the equity. A sues B for 10,000. B cannot sell off, claim to set off any amount due to him towards salary for performing illegal, immoral activities of A. If the law recognizes two types of set off: legal set off, equitable set off. Order 8 Rule 6 deals with the legal stuff. But the said provision is not exhaustive and does not take away the powers of the court in allow such adjustment or independent. Of the Rule 6 and Order 8 is known as equitable set off. Equitable set off. Okay. Conditions: A defendant may or may claim a set off if the following conditions are satisfied. The suit must be for recovery of money. Soup of money must be ascertained. Such sum must be legally recoverable. It must be recovered by the defendant or by all the defendants if more than one. It must be recoverable by the plaintiff and the plaintiff on both sides if more than one. It must not exceed the pecuniary jurisdiction of the court in which the suit is brought. Both parties must fill in the defendant's claim to set off the same character as they fill in the plaintiff's sum. Effect of set off. Here is the when the defendant pleads a set off, he is put in a position of a plaintiff as regards the amount due to him. There are two suits, one by the defendant by other by defendant, others than the defendant against the plaintiff. They are tried together. A separate suit number, however, is not going to set off. Where the plaintiff does not appear in for detailed discussion for capital. Equitable self. His suit is dismissed for default as he withdraws his suit, or he fails to substantiate his claim and function, and his suit is dismissed. It does not affect the claim for a set off by the defendant, and decree may be passed in favor of the defendant if he is able to prove his claim. Equitable set off. Rule 6 begins leads with legal set off only if it is allowed by the Court of Commons in England. It is always in respect of an ascertained sum of money, but there are many cases in which the defendant may be allowed to set off in respect of an unascertained sum of money. The provisions are, however, not exhaustive. In addition to legal set off, equitable set off, as allowed by the courts of equity in England, it may be claimed by the defendant in respect of even an unascertained sum of money, provided both the cross demands that are out of one and the same transaction are also connected in the nature of and circumstances, and that can be looked upon as part of one transaction. Thus, where A sues B for recover 50,000 under contract, B can set off towards damages sustained by him due to breach on the same contract. By A, likewise, a suit by a servant against his master for salary, latter can claim set off for loss sustained by him because of negligence or misconduct of the former. Since such claim arises out of the same relationship, again, a suit by a washerman for his wages, then defendant employer may set off the price of the clothes lost by the plaintiff. Legal and equitable set off distinction. Legal set off must be for an ascertained sum of money. Equitable set off may be allowed even for an unascertained sum of money. Legal set off can be claimed as a matter of right, and the court is bound to entertain and adjudicate upon it. Equitable set off, on the other hand, cannot be claimed as a matter of right. Court has discretion to reduce to adjudicate upon it. In a legal set off, it is not necessary that the cross demands arise out of the same transaction. Equitable set off can be allowed only when the cross demands arise out of the same transaction. In a legal set off, it is necessary that the amount claimed as set off must be legally recoverable, must not be time barred. Claim by way of equitable set off may be allowed even if it is time barred when there is a fiduciary relationship between the parties. Thus, a trustee in possession of the trust estate may, by way of equitable set off, claim to be indemnified out of the trust estate when called upon to account, even though he can claim such indemnity is time barred. It must, however, be noted that even in the case of equitable set off, if at the end of the trust statement the defendant's claim is time barred, though not barred at the date of the suit, it will be allowed only to the extent of plaintiff's claim, but a decree will not be passed in his favor for the balance found due to him. A legal set off requires a court fee, but no court fee is required in the case of equitable set off. Set off and counterclaim. Counterclaim rules 6A and 6A, meaning 6G. Counterclaim can be defined as a claim made by the defendant in a suit against the plaintiff. It is a claim independent of and separable from the plaintiff's claim which can be enforced by a cross action. It is a cause of action in favor of the defendant against the plaintiff. Doctrine explained. One of the pleas upon a defendant to defeat the relevant relief sought by the plaintiff against him in a counterclaim. Counterclaim may be defined as a claim made by the defendant in a suit against the plaintiff. Therefore, a defendant in a suit may, in addition to his right to plead, set up a counterclaim. It may be set up only a set up claim for which the defendant can file a separate suit. Thus, a counterclaim is substantially cross-action. Before the Amendment 76, there was no specific provision for counterclaim for the court. The Supreme Court, however, held the right to make a counterclaim statutory. It was held that the court has power to treat the counterclaim as a cross suit, and here the original suit and counterclaim together of the counterclaim is properly stamped. In the leading case, Lakshmidas versus Nanabhai, Supreme Court addressed the question and therefore to be considered in principle as to whether there is anything in law, statute, or otherwise which precludes a court from treating a counterclaim as a plaintiff in a cross suit. It is difficult to see any, no doubt the Code of Civil Procedure persuades the content of a plaint. It might very well be that a counterclaim, which is to be treated as a cross suit, might not conform to all these requirements, but they themselves is not sufficient to deny to the court the power and jurisdiction to read and continue the proceedings in a reasonable manner. If, for instance, what is really made of a part and wooden written statement, otherwise seeing made next to it as a part of the parcel thereof. Though described in a counterclaim, there could be no legal objection to the counterclaim treating the same as plaint and granting such relief to the defendant, as it would have been opening of the pleading of taken in the form of a plaint to hide, or whether it would be erect what in substance is a mere defect in the form of pleadings into an instrument object. Before Amendment 1976, no counterclaim was set off. The Law Commission of India, however, recommended to avoid multiplicity of proceedings, right to the defendant to raise the plea of set off in addition counterclaim in the same suit. 2 excluding inconvenience bodies of nature and scope. As the amendment of 76, specific provision has been made to counterclaim by inserting Rule 6A to 6G. Under sub-Rule 6A, the defendant may set up a way of counterclaim against the claim of the plaintiff or any right and claim in respect of action accruing to the defendant against the plaintiff, either before or after the filing of the suit, but before the defendant has delivered his defense on before time fixed for delivery of defense has expired both. Such counterclaim, however, should not exceed the pecuniary limit of the jurisdiction of the court. In other words, by laying the counterclaim pecuniary of jurisdiction of the court cannot be hosted, and the power to try the suit already entertained. In a suit for injunction, counterclaim for possession can be allowed. Modes of setting up those three state modes of writing or setting up a counterclaim in a civil suit. In the written statement filed. Now it is defendant who may file a counterclaim against the plaintiff is necessary to take with the plaintiff. Defendant may claim relief as the covenant. Why counterclaim may be set up? A counterclaim may be set up by a defendant against the plaintiff in respect of cause of action accruing either before or after filing of the suit, provided such claim is not barred by limitation. Effect of counterclaim. Such counterclaim has the effect of a cross suit, and the court can pronounce a final judgment both on the original claim and counterclaim. The counterclaim of the defendant will be treated as a plaint, and the plaintiff has a right to file a written statement in answer to the counterclaim of the defendant. The effect of the counterclaim is that even if the suit of the plaintiff is stayed, discontinued, dismissed, or withdrawn, the counterclaim will be decided on merits. With the defendant will have a right to get a decree for counterclaim as claimed in the written statement. If the plaintiff does not file any reply to the counterclaim made by the defendant, the court may pronounce the judgment against the plaintiff in relation to the counterclaim made against him or make such order in relation to the counterclaim as thinks fit. The counterclaim shall be treated as a plaint and will be governed by rules applicable to plaint. Similarly, a reply filed in answer to counterclaim shall be treated as a written statement and governed by rules applicable to written statement, set off, and counterclaim. Distinction between set off and a counterclaim is very important, therefore must be carefully considered. Set off is a statutory defense to the plaintiff's action, where the counterclaim is substantially a cross action. Set off must be for ascertained sum, or it may arise out of the same transaction. Its counterclaim need not arrive out of the same transaction. Set off It's a good. 219, page number set off. Set off is a statutory defense to the plaintiff's action, whereas counterclaim is substantially cross-action. Set off must be for an ascertained sum, or it must arise out of the same transaction. A counterclaim need not arise out of the same transaction. Set off is a ground of defense, where to the plaintiff's action, in other words, answer to the plaintiff's claim to in the case of a legal set-off, the amount must be recoverable at the date of the suit, while in the case of the counterclaim, amount must be recoverable at the date of written statement. When the defendant demands in a plaint some amount blow up or up to the suit claim, it is set off stricto sensu, but when it is for a larger amount, the claim for excess amount is really a counterclaim. Over.